Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of Indraprasth Law College. Although we have already discussed in detail about the historical evolution, nature, scope and sources of international law in the previous lectures, but now in today's lecture number 7, we are going to discuss about the relations between international law and municipal law in detail. So now let's open the today's magic box and start the slide. While international law is applied in the relations of the states to other subjects of international law, national or state law, which is called municipal law, is applied within a state to the individuals and corporate entities, which are the barriers of rights and duties are there under. Apparently, it might be looking that there is hardly any relationship between the two systems, as they constitute two different legal systems, each of which is designed to operate in its own sphere, and they are applied distinctly to their subjects by different courts, but it not so. So here we may discuss about the international law versus municipal law. Basically, public international law, or you may also known as a international law, and national law, which is also known as municipal law or common law, are the two legal systems where national law governs the domestic relations between the officials authorities of a state and between these authorities and individuals, as well as relations between individuals themselves. And while the other side, public international law governs primarily the relations between the states. Let's move on the next slide. In that slide, you may see that to clarify the relations between the international law or the municipal law, there is a two kinds of theories, which is known as firstly dualist theory and the other one is monist theory. So let's open the next slide. And discuss about the dualist theory. What is the dualist theory and the meaning of dualist theory? The dualist theory considers that international law and national law are two separate legal systems which exist independently to each other. बेसिकली डुअलिस्ट थ्योरी के जितने भी राइटर्स थे वो यही मानते हैं कि पब्लिक इंटरनेशनल लॉ और जो म्यूनिसिपल लॉ है, इंटरनेशनल लॉ और म्यूनिसिपल लॉ, दे आर बेसिकली different from each other. Each of these two systems regulates different subject matters, functions on different levels, and each is dominant in its sphere. As you know that public international law primarily regulates the conduct of sovereign states, while national law regulates the conduct of persons within a sovereign state. On this view, neither legal system has the power to create or alter the rules of other. So next one is then now we may discuss about the monist theory. According to the jurist opinion, the monist theory, which upholds the unity of all law, regards international and national law as forming part of same legal system. इसका कहना था कि इंटरनेशनल लॉ और लॉ म्यूनिसिपल लॉ बेसिकली एक ही सिक्के के दो पहलू हैं. It argues that both laws are based upon the same premise, that of regulating the conduct and the welfare of the individual. दोनों का एक ही मकसद होता है, that is the welfare of the individual. However, it asserts the supremacy of international law over national law, even within the national sphere in the case of a conflict between the two laws. International law is supreme, according to some jurists. But someone denies in this approach. Let's move on the next slide. Now we already know about one of the most important source of international law, that is international custom and treaties. That's why there is the opinion of the monist and dualist approaches regarding the municipal and international law, and try to differentiate both within the aspect of the various jurists. Monist versus dualist theory. Both of the view that the two systems of law differ from each other on the following grounds. If we may discuss regarding the sources, according to dualist, the source of municipal law are customary, and they are grown up customary within the boundaries of the state concerned and the statutes enacted by the sovereign. And the source of international law are also customary among the states, but among the states and lawmaking treaties concluded by them. So the first one, you may see that the sources in the preview of the sources, dualist theory says that the boundaries of the state concerned and the statutes enacted by the sovereign, and the international law grown up among the states and lawmaking treaties concluded by them. Let's move on the next slide. Now we may discuss regarding the subjects. Dualists are of the view that the subjects of international and municipal law are different from each other. While municipal law regulates the relation between the individuals and corporate entities, and also the relation between the state and the individual, as we already know that, while the international law regulates primarily the relations only between the state. And the next to discuss regarding the substance of law. Substance of the laws of two systems is also different. While municipal law is a law of sovereign over individuals, international law is a law not above but between sovereign states. Its norms are created by its subjects themselves. Thus, municipal law addresses itself to the subjects of the sovereigns, international law to the sovereigns themselves. Next is that regarding principles. Just as one cannot talk in the terms of the supremacy of one national law over another, but only of two distinct legal systems, each operating within its own field. So international law and national law should be treated in the same way. Each law exists within a different judicial order, because the above opposing theories in reality do not adequately reflect actual state practice, and the scholars in each side have forced to modify their original positions in many respects, bringing them closer to each other without, however, producing a conclusive answer on the true relationship between international law and the national law. This fact has led some legal scholars to pay less attention to these theoretical views and to prefer a more empirical approach, seeking practical solution in a given case. The method of solving a problem does not probe deeply into theoretical consideration, but aims at being practical and in accord with the majority of the state practice and international judicial decisions. So, regarding the principles of the comparison between monist and dualist theory, And duality is of the view that while municipal laws in a state are obeyed because they are the principles of state legislature, and international law is obeyed because of the principles of pacta sunt servanda. That is a Latin term which is most important in the international law. We may discuss later on in the next lectures what is the pacta sunt servanda. Thus, while in the municipal law here is a legal sanctity, and international law is followed because states are morally bound to observe them. So there is a less sanctity in the case of international law. Hope you will have been enjoyed the whole session and successfully enumerated it into your study and be benefited from this presentation. Thank you. We will meet soon again with a new session. Thank you very much.